Okay, maybe we should start now. Okay, allow me to give a brief introduction and welcome everyone to this webinar on China and ASEAN arbitration, current development and opportunities. This is an event co-organized by BAIAC International Arbitration Center, or BAIAC, and the Faculty of Law, Thammasat University to commemorate the signing of our MOU earlier this year. So BAIAC International Arbitration Center is a Singapore-based arbitration center focusing on international commercial disputes arising from ASEAN, China, and the Belt and Road Initiative countries. Based on the MOU, Thammasat and BAI hope to develop cooperation in the area of arbitration training, education, and research involving the ASEAN region with a focus on Thailand, Singapore, and Guangxi. And today we have two distinguished speakers with us today, and allow me to introduce them to you. So the first speaker is Professor Joshi. Professor Shi is a professor and the founding director of the Center for International Economic Law and Policy, University of International Business and Economics in China. He specialized in international trade and investment law and policy, dispute settlement, global development, and corporation law. Apart from his academic activities, he has also sat on many international committees, including the International Law Association Committee of Rule of Law and International Investment Law, and also the steering committee of the Arbitral Academic Forum on ISPS reform. He has been involved in many arbitration proceedings, either as an arbitrator or expert witness. With us today, the second speaker is Professor Steve Ngo. Professor Ngo is an expert in international arbitration and dispute resolution. He's the founding president of the BAIAC International Arbitration Center. He has been involved in matters involving arbitration rules of many institutions, such as CTAC, London Maritime Arbitration, ICC, SIAC, Permanent Court of Arbitration, LCAA, Hong Kong International Arbitration Center, and ICSID. In addition to international commercial arbitration, he has been consulted on investor-state arbitrations as well. He is also an arbitrator at the Thailand Arbitration Center, or THAC, as well as many other esteemed arbitration institutions. And it's my pleasure to be your moderator today. My name is Amna Tangkripiman, and I'm the lecturer at Faculty of Law, Thammasat University. Today's session will take about 1 to 1.5 hours. We will start with Professor Ngo's presentation, and he will tell us about ASEAN countries' different arbitration laws and their adoption of Arbitral model law and the New York Convention and some regional developments. And then we will follow by Professor Shi's presentation, which will focus on Chinese arbitration law and its recent development. Without further ado, Professor Ngo, the floor is yours. Thank you both for being here with us today. And sorry, and if any participants have any questions, feel free to type it down in the chat box, and I will collect the questions and ask our speakers today. Sorry for the interruption, Professor Ngo. The mic is yours.
Thank you very much, Dr. Amnat, for the very kind introduction. And I thought, being a co-organizer of today's event, I also would like to welcome Professor Chi to this event today. Professor Chi is a good friend of arbitration, so to speak, and an upcoming and a well-known international arbitrator who is making his mark in the region. And I think I'm sure I'm in good company to say that Dr. Amnat, Thammasat, and BAIAC are happy to have, and very honored to have Professor Chi with us today. So today's topic is on the China-ASEAN current present development and opportunities. You will hear a lot more from Professor Chi, particularly in relation to the upcoming major revision to the Chinese arbitration law, which will impact rather positively on all of us. And I'm sure not only that the participants will have a lot of questions to ask, and I think I would also like to jump on the bandwagon to ask questions and to discuss this interesting topic. But before that, let me begin by giving a very brief update about the situation in the 10 ASEAN countries, or referred to as Southeast Asia. So I will share my PowerPoint slides. Right. So I think there is no need for introduction as to who the 10 countries are. But for the benefit of those who might not be familiar, very briefly, from the infographics, you can see that the 10 ASEAN countries, they are there. Right from the top, I guess, first will be Philippines, then you have Laos, Vietnam, Brunei, Singapore, Malaysia, Indonesia, Cambodia, Thailand, and Myanmar. So these are the 10 ASEAN member states of ASEAN, or the Association of Southeast Asian Nations. Right. It is also imperative at the beginning for me to highlight the economic importance of ASEAN and its neighbor. Because essentially, dispute resolution mechanism or commercial dispute resolution mechanism such as arbitration is created precisely for reasons like this, for trades, international trade and commerce investment between these countries. And if we looked at this infographic again, I think again it requires no convincing or introduction again that ASEAN and its surrounding country, the ASEAN Plus countries, if you can look at this very succinct infographic, tells us all about it. And again, it's no secret. We all know the importance of trade relation between good neighbors in this region. What might be of interest to some of us is that how does it pan out? The 10 ASEAN countries. I often like to say that the 10 ASEAN countries are different countries coming together as one. Because of the different legal system, government, and of course, in this instance, let's look at the arbitration background, or the factual background relating to international dispute resolution and arbitration. So, looking at the adoption of the UNCITRAL model law, for instance, we will see that out of 10 countries, therefore 70%, 30%, which means 7 countries have actually adopted the UNCITRAL model law, whereas the other 3 do not adopt the UNCITRAL model law. More details will be shown later on. I'm just giving you the general perspective. And then, in terms of the legal system, why this is important? Because for various reasons, among others, when selecting the seat of arbitration, the juridical seat of the arbitration, this matters. And as well as perhaps the use of governing law or substantive law. And if we look at it, it might surprise some of us, particularly those among us who may not be already familiar with this, is that out of these 10 countries, indeed, it is multicultural, so to speak. We have 40% civil law jurisdictions, countries, only 30% mixed, and I'll explain that shortly. And only 20% adopts the English common law, and with 10% a combination of civil and common law. Now, this is the full tabulation of each of the countries' profile. Right at top in alphabetical order. If we look at Brunei, it has a mixed legal system, which is ENG here, English, customary, and Sharia law. Yes, it adopts the model law in 2009 and also member state or signatory of the New York Convention since 1996. Followed by Cambodia, again, a civil law system, adopts the model law in 2006. Indonesia, a civil law jurisdiction, but does not adopt the UNCITRAL model law. And in Laos, a civil law country, largely French system, the former French system, and it's not a model law adoptee. Malaysia, a common law and Sharia and customary. Myanmar, mixed. Philippines, Singapore, of course, where I am. Thailand, and in Vietnam. Now, from the summary of this table, I think it is interesting, and it tells us quite a lot of things. Firstly, not all the countries adopt model law, as we have seen from the chart, the pie chart, only 7 out of 10. However, thankfully, all the 10 ASEAN countries are signatories of the New York Convention. The last joining being Myanmar in 2013, which was 8 years ago. So I think it is important, whilst much has been said about the importance of the model law and the purpose of the model law, the very spirit of UNCITRAL itself for the harmonization and unification of international trade law. But we also recognize that the use of a model law, in this instance, the model law international arbitration, commercial arbitration, helps to standardize across the board so that there will be no surprises and that there is vast predictability when it comes to the practice and procedures of arbitration, particularly the conduct of arbitration. Now, this is important because, among other reasons, with regional trade, volume of regional trade increasing, then we are seeing, and of course, with the promotion of arbitration, yes, most importantly, and we are seeing these days, not only, although primarily most arbitration is conducted in Singapore, using Singapore as a neutral seat, but we're also seeing arbitration being conducted in other parts of ASEAN, very much in line with the growth of regional and cross-border trade in ASEAN. And the advantage of the model law is that when I mentioned early on, predictability, one of the key reasons, is also that the model law is a tried and tested model law, a template, so to speak, a template that the countries can adopt so that not only that it helps each of the countries to be familiar with each other, putting them in a familiar position of knowing each other's law so that we don't expect any surprises, as I mentioned earlier on, but it also helps to put into use or to implement current practices that is in line with the present day development of international arbitration, practice on international arbitration, purely for comparison purposes. Right? It's not intended to be a review or a critique, so to speak. Let's take, for example, like the Indonesian arbitration law, which has been quite a while. I believe it's a 1994, 1999 arbitration law that is yet to be adopted, to be updated. And there is one interesting provision, for example, in the Indonesian arbitration law. It stipulates that an arbitrator must be 35 years of age, 35. I have been asking around for the longest time, due to my involvement in Indonesia for a long time. I've always been asking this very important question, asking people that I know, people whom I believe they are who knows the arbitration law very well. Why 35? And we haven't quite gotten an answer why it's 35. But again, as I said, it is not intended to be a critique, although we know that in a model law provision, there is no stipulation about age, although we know that in some arbitration laws, perhaps, I think Professor Chi can correct me on that. I think the Chinese law stipulates working experience, I think 10 years of working experience. Now, that is not intended to be a cheeky way of working backwards to find out a person's age. I suppose it's not quite the issue. But in my opinion, it makes sense because, how can you be an arbitrator if you have not attained certain level of seniority or expertise? So 10 years sounds correct. And then again, if we will do the maths, probably that's where we'll end up with 35 years of age. So like I say, it's not intended to be a critique, but although in the first instance when we read it, and those who are unfamiliar with such provision will probably be a little bit surprised why it goes to the extent of stipulating the age, you see. But then again, because all these arbitration laws were all devised back then according to the requirement or the policies existing back then, and before we know it, time flies, and we are where we are today in the year 2021. So that is precisely one of the advantages of adopting the model law, because as the model law updates itself, not just by one country or two countries, but we're talking about the membership of the UNCITRAL, which we're talking about a major thing, that they have this major consultation documenting all the or the proceedings of the discussion. So that is why. Anyway, I'm not here to promote the use of the model law. That would be the job of our Arbitral, and it's still a work in progress. But nevertheless, I think it is important for us to at least take comfort in the fact, as I already said earlier on, that all the 10 ASEAN countries adopts the New York Convention, a very, very important convention for the enforcement and recognition of foreign arbitral awards. And in fact, it is said that the New York Convention is the single most successful international treaty by Arbitral. And of course, the New York Convention for arbitration, and we have Singapore Convention for mediation. There's probably another day's discussion, but it's worthwhile mentioning how we are possibly aiming for a complete set of conventions out there. So with arbitration that has its New York Convention since 1958, and with Singapore Mediation Convention in the last 2 years that was promulgated 2 years back. Now parties now have a choice, and instead of arbitrating, they could go for mediation, and mediation will no longer be the poor cousin of arbitration. Now it has its teeth now. It's not just a paper tiger, so to speak. But anyway, we are glad that at least this is the present situation that, as we can see in the ASEAN countries. Now, moving on, I will very quickly go into the point about the recent developments, at least up to 2021, insofar as ASEAN is concerned. Now, apart from all those minor development or updates or progress, I'm not going to go into those details in the interest of time due to time constraint, but I'm just going to talk about two important things in terms of the development that were of interest to you and me largely. The most important, of course, being the first one. The first one here is that, let me just give a very quick introduction here. It's the new Singapore-Indonesia Bilateral Investment Treaty. Now, within this treaty, it has a very interesting arbitration protocol. Perhaps I should say it is a milestone development, and that may address some of the concerns, grievances, issues pertaining to arbitration. I will explain to you shortly. It gets me really excited talking about this protocol. And also this protocol might set a new benchmark going forward, progressing from here, as to how arbitration may be done at the investor state level. And we might expect that spillover effect on other aspects of arbitration. Now I'm going to move into that now. Very briefly, by way of introduction, Indonesia has been ramping up termination of its bilateral investment treaties since 2014. They've been terminating that. There are many reasons for that. One of the key reasons being, the facts speaks for itself, unfortunately, is that if you even turn to its website, between 1990 and 2016, Indonesia had about 12 arbitration against the state by investors initiating arbitration against the states. And this is not a very flattering number, and Indonesia knows that. And it's not nice to be taken to arbitration all the time. And Indonesia being a very big country, very open to international investment and trade, and a system of a decentralized government and a local government, often finds itself in a very disadvantageous position when facing disputes or arbitration actions by investors who are well prepared. And of course, as we know, investors are always well prepared. They come prepared. As a claimant, also, they come prepared. They know what they are doing, and they have got all the ammunitions and they've got all the master plan or the blueprint ready to take a country or state to arbitration. So this is one of the reasons why Indonesia felt that, why are we always at the other receiving end? Why is this always happening to us? Perhaps there are some things that we need to address. Yes, some of the arbitration clauses, so the arbitration procedures, they felt that there is room for improvement. More can be done. whilst at the same time the country recognized the importance of BIT. We need BIT, right? They recognize the importance of it. But in terminating all the BITs, they were hoping then to introduce BITs that incorporates dispute resolution clauses that they desire. And why this is important? Because not only that, this is the first new BIT, it is a BIT between Indonesia and Singapore, another fellow ASEAN countries. So I don't know of any new BITs other than this one, which was actually entry into force this year, in fact, although it was signed in 2018 in Bali. But I have reasons to believe, correct me if I'm wrong, any of the participants' audience, if they have any new information, I'm happy to hear that. But I believe this Singapore-Indonesia new BIT is the new BIT, or the new order BIT after Indonesia has actually ramped up the termination of all the other BITs. Right. So I've said this, as I've said earlier on, this new renewal BIT, it's not the first BIT between Indonesia and Singapore, of course. There was a previous version. The immediate past version was signed, I think, in 2005 and entry into force in 2006 and expired after 10 years and came up with a new BIT. And this new BIT was signed more than 2 years ago, on the 11th of October 2018 in Bali. And but I believe maybe due to reasons of all the countries prioritizing prioritizing in battling the pandemic, and so naturally things like this get pushed back. And it was only put into force, entry into force on the 9th of March 2021, a couple of months ago. Well, I'm not going to go into too much explanation or details about the BIT. Singapore is an important trading partner of Indonesia. It is so important because, to some extent, many of the foreign investors would be investing in Indonesia through Singapore. So what they will do is to set up investment holding companies in Singapore for the purpose of investment in Indonesia or entering Indonesia. So that is the reason why the data again speaks for itself. Indonesia and Singapore has a very active investment relationship, so to speak. Now, so as I've said earlier on, that this new dispute resolution mechanism might prove to be a new standard, might set a new benchmark for others to emulate. Without further ado, I'll just go into it right away. Very briefly, the dispute resolution or settlement mechanism is provided under Chapter 3 of the BIT in 2 sections. But I'm not going to talk about the second sections today because the second sections tend to be not as important, not really a hot spot, so to speak, compared to the first section. And the first section is settlement of disputes between an investor and the state party, right? Investor and state party, which is the investor-state dispute settlement. Now, this is very important. If you look at this infographic, this chart, in the event of a dispute, there is a compulsory consultation provided for under Article 15. Compulsory consultation. Now, some of us who are familiar with how dispute resolution mechanism works will probably understand that consultation tends to be that very tricky thing, right? That sometimes it appears in contracts. Sometimes there is a requirement for mediation, attempt to mediate or to negotiate before commencing arbitration. Parties who have made up their mind or resolved not to negotiate or mediate will then proceed to arbitration. We'll find all sorts of means to bypass these 2 steps. But in the BIT, it makes it mandatory. And in the process of the consultation, if the parties would like to mediate, they can mediate. Now, the point is this: the arbitration cannot be commenced at least after 1 year from the commencement of consultation, negotiation. In other words, you must negotiate first before you can commence arbitration. I'll come to that later. The part. So yeah, first thing first, on consultations. So consultations and negotiations. The place of consultations either in Jakarta or Jakarta or in Singapore. And It is not non-binding. It's non-binding. The procedures or the process are provided for. Commenced within 30 days of receipt by the state party and so on. Let me just move. Okay. Right. Now, then in between, the parties can mediate, and the mediation is purely voluntary. Purely voluntary to the extent that if you looked at Article 16.1, you can download the BIT for the internet, from the website, from the web. There's this interesting provision. It says to give, and I quote, to give sympathetic consideration to the request. So in other words, it's really voluntary in the sense that there is no compulsory mediation. Compulsory negotiation or consultation, but not mediation. And the mediation procedures will be subjected to a code of conduct of arbitrators and mediators, which is quite rare. And it is at the request of the party to provide a factual report, but it will not include any interpretation of the agreement. And that and the last point here, very interestingly, nothing in this article, which is in the mediation, the article of mediation, the chapter, the clause of mediation here, the provision mediation, shall preclude the disputing parties from having recourse to other forms of alternative dispute resolution. Which means, what are the other alternative form of dispute resolution in this BIT? Arbitration. My only guess is that this was formulated before the Singapore Convention came into force. Why I'm saying this is because clearly, very evidently, we are seeing this lack of powers or the teeth for mediation in this BIT. I suspect that if this would be happening after the Singapore Convention, and of course taking into consideration that although many countries have signed the convention, a form of a commitment and a pledge, but not many have ratified it. I think to that probably we have a few more agreeing to ratify or informing UNCITRAL of its intention to ratify the Singapore Convention. Probably we are like 8, I think, or so. Now, I suspect again that if we would be drafting this BIT on mediation provision after the Singapore Convention has been put into place sometime in August 2019, I think it will probably be a different wording altogether. May give mediation a lot more power, a lot more kick, so to speak. But nevertheless, the parties want it this way, so that the drafters of the BIT wanted it to be this way, where the mediation is purely voluntary, and a lot of emphasis on the consultation process, that 1-year process. Yes, on the arbitration mechanism here, the arbitration can only be commenced 1 year following the commencement of the consultation, and by that it means the delivery of the written request for consultation. So in short, you can only commence the arbitration after 1 year. Is it a long period of time? My answer is yes. I think it's quite a long period of time, 1 year. This is the first time I've seen something like this. We have seen things like 30 days, maybe 60 days, but still parties will find ways to circumvent that. But here, it's clearly compulsory consultation, and you can only commence arbitration after 1 year. It's quite long. It may change a lot of things, to be honest. Okay, and I can't speak for any of the parties here, the drafters, that is. I mean, from the standpoint of a state, the state will probably want to discourage frivolous or unmeritorious claims by investors. So by giving them 1 year, if they have a real genuine case, then they would proceed to arbitration a year later. But if it is a frivolous or unmeritorious claim against the state, probably they will change mind after 1 year. Now I'll continue. So the disputing party may choose to submit the dispute and choose one of the following options available. These are very standard wordings in the BIT. I'm not going into that details. Either it's an ad hoc arbitration under UNCITRAL rules, or an arbitration administered by its seats, or institutional arbitration under commercial arbitration rules, but subject to the agreement of the parties. And there is a time bar. So the submission to arbitration must be within 3 years, or should have recently become aware of the parties. So there's a time bar of 3 years. So you can't just come back after 5 years, 6 years, and whatever the number may be, and go after the state party. And here it requires 3 years. So 3 years. There's a limitation period here. And here's another interesting one. The Article 17(2)(d) that requires the disputing investors to provide written notice at least 90 days before the claim is submitted. So 3 months, you have to provide a written notice, a notice of arbitration first, and at least 3 months before you put in your claim. So again, 3 months is quite a long period of time. And other interesting provisions that I've actually taken from the BIT and share with you here today is that we all know about the use of third-party funding, very popular, very important these days, and there is a need. It is mandatory to disclose the use of third-party funding, and I'm sure this is not this is important, but I believe many arbitral institution rules and or present practices have require parties to disclose any other vested interests, i.e. the use of third-party funding. But it is good and important for this to be put in the BIT, because we can expect a lot of third-party funding in investor-state arbitration, given that the value and the quantum may be large and a lot is at stake. And so investors may receive fundings, and states need to know that, the parties need to know that. Another thing is, which is quite unprecedented as well, is that the arbitrators will comply with a code of conduct. I will show it to you later, the code of conduct. In fact, there's also one that applies for the mediator. That cost, okay, costs follow the event, Article 25. Okay, this may not come as a surprise to some of us, something quite common. But I would like to point your attention to Article 26, security for costs. Now, some of you may already may be familiar with security for costs in arbitration, but here it is a security for costs requested by the states. This is very interesting. Again, this is quite unprecedented. Here, it is basically another layer of, well, probably another layer may not be the right word. My apologies. But here, this is another step towards dissuading frivolous claims by states. So with what you have seen just now, earlier on, 1 year consultation, only 1 year after consultation that you can commence arbitration. And then that 90 days limit, that 90 days requirement before you can put up your claims. And then the state may then ask the investor to put up security for costs. And if the investor has a good case, and perhaps then we'll have to get funding for third-party funding to fund the arbitration. Well, the state can ask for that. That's under Article 26. And lastly, Article 28. Again, very interesting. So if the disputing investor fails to take any steps in the proceeding within 180 days or 6 months, then the investor will have deemed to have withdrawn its claim and discontinued the proceedings. Now, I won't go into the details of this 180 days, but suffice to say, sometimes, for whatever reasons, the claimants may end up dragging its feet. No action, inaction. And that frustrates people, right? Because you have a claim, and then you initiated and commenced the arbitration, and the third party will have to find funding, hire external counsels to support them, and then the claimant drags his feet. Although that may be rare, But the point is, it can happen, and certainly we have seen that happening in commercial arbitration. So this is like a carrot and stick thing, and it's actually putting making the investor or the claimant, the claiming party really works for it. If you really have a case against us, then you got to move fast. Don't drag your feet. Don't sit on it and wait for something to happen. Who knows what might it be? Perhaps who knows that the claimant might need to obtain third-party funding. Halfway through, they decided that they need third-party funding, and the third-party funder may take time to underwrite or to evaluate the case, and who knows, right? It might be 180 days, it might exceed 180 days. So there are many possibilities, but this is something new, and something that we will probably welcome in time to come, not only for BIT arbitration, but even for commercial arbitration. Right. Speaking of the code of conduct for the arbitrators and mediators, first thing first, generally there is nothing out of the extraordinary. As in the responsibilities of independence, impartiality, disclosure, and so forth. But here are some of the interesting points, some of the selling points. At paragraph 10 of the Code of Conduct, it states that an arbitrator shall not deny other arbitrators the opportunity to participate in all aspects of the proceedings. There was a case more than 20 years ago, I suppose, or almost 20 years ago, of an infamous case of an arbitrator who was kidnapped while on the way to participate in an arbitration in Netherlands. So this reminded me of that incident. I can't, of course, say that there is any similarity between these two, or there is any connection, between the paragraph 10 and that incident, of course. Yeah, it's up to interpretation what it means by one arbitrator shall not deny the other arbitrator an opportunity to participate in the proceedings. Now, the other noteworthy points, again here, also being that with the use of arbitral tribunal secretary, tribunal assistant, and here is referred to in the BIT and the Code of Conduct as an assistant and a staff, so it distinguishes two. An assistant, for the interpretation, it is akin to tribunal secretary, and whereas the staff is someone who works under the tribunal's supervision. Now, the tribunal and the tribunal assistant secretary and the staff, or the assistant and the staff, must also comply with the independence and impartiality requirement. And as confidentiality is understandable, but if they are required to comply with the independence and impartiality requirement, which is something new, which is a first. And also to keep a record and render a final account of the time, etc. Assuming that presuming therefore that the parties will also be paying for the cost of the tribunal secretary and assistant, because sometimes it comes from the tribunal's fees, but in this instance, in many cases, the parties will be paying for it, and the parties want the tribunal assistant to also keep a tab on the costs and expenses. Now, very quickly moving on in the interest of time. So I'm going to go to the second part now of this update. A very authoritative QMUL, Queen Mary University of London report, the annual report, the much awaited report, and the report for 2021 published this year, in other words, for survey last year. It's always 1 year later. 2021 report means it was a survey of last year, 2020. Has actually reported that Singapore is now alongside London as the preferred arbitration seats or venue in the world. For many years, Singapore has been the #1 arbitration seat or venue in Asia, #2 in the world. Now it is on par with London as the #1 preferred venue. I know this kind of news may sometimes attract the right or the wrong response, but there is no right or wrong answer or response, to be honest. While some commentators believe that competition, quote and unquote, competition is good, but on the other hand, let's also accept the fact that arbitration is not a game of chance. So parties select a seat, a juridical seat or place of arbitration, not necessarily because it's a fun place, it's an exciting place, but there's a lot that goes into it. And Singapore have worked very, very hard for that. So here I mentioned it's just not just a fun place. I know the young generation like to use the word fun, which the word fun sometimes may actually gives a negative connotation, the playfulness of it. But actually, in reality, there are many things in life which is not all about fun and having fun. Right? A very serious affair. Arbitration is a very, very serious thing. Now, why Singapore continues to dominate, I suppose, not only that we have built that reputation, and we are building that reputation as international arbitration hub, not so much because we want to become the #1 place in the world. I beg to differ that it's not necessarily because Singapore always wants to be #1, but because we happen to be we happen to work on our strengths, and one of our strengths, our judiciary, our government, and strong economy, and that organically presents an opportunity for us to develop our capability and capacity in arbitration. So here I would like to point out two things. Very importantly, I think, is that the use of Singapore law from two perspectives. The use of Singapore law, #1, in terms of the use of the Singapore arbitration law, and the use of the Singapore law as a governing law. So the use of Singapore law as governing law, we know that for the substantive law aspects of it. It used to be a lot of contracts traditionally governed by the English law, for example, but these days we're seeing a lot governed by Singapore law, particularly when both the parties have no connection to Singapore whatsoever, and the disputes may not even have any Singapore connection. And the other use of the Singapore law that I would like to point out that some may not realize this is that by choosing Singapore as a seat of the arbitration means the arbitration will be governed by the Singapore arbitration law. And when the arbitration is governed by the Singapore arbitration law, clearly we are using the Singapore law. So when parties stipulate the seat of the arbitration, the juridical seat of the arbitration, and the juridical seat may not necessarily be the evidentiary place of hearing. Parties could conduct their oral or evidentiary hearing in another location of convenience, as is the case with COVID and with the pandemic, the arbitration where most arbitration, okay, let me just take one step back. Many arbitration are conducted virtually, and therefore they may not be physically present in the location stipulated in the contract. So the evidentiary place of hearing is purely a place of convenience for the parties. But whether or not you would be conducting your evidentiary hearing in Singapore, should your contract provide for Singapore, it doesn't matter because the parties can do it online. But the fact is, at the end of the day, the arbitration award is a Singapore-seated arbitration award. And by now, you would know that the theory of the seats is a very important concept in international arbitration. So there you go. At the Singapore arbitration law, by selecting Singapore as a juridical seat, we have agreed to the application of the Singapore arbitration law due to the juridical seats. And the same Singapore arbitration law also allows parties to seek support or assistance whenever provided under the Act, under the law, to seek support or intervention or assistance from the Singapore courts. So there is a much broader picture here in the international arbitration, not just the mere use of the Singapore law as a governing law of the contract, but also when parties selected Singapore as a juridical seat, and therefore the Singapore arbitration law will apply. Other salient features, the judiciary, the constant jurisprudential development of arbitration in Singapore, a very safe, tried, and tested jurisdiction. I'll just move on very quickly now in the interest of time. And also the use of technology has been, we can see, for example, one of the major player provider of arbitration services is Maxwell Chambers. They provide now a hybrid concept of arbitration. It used to be in person, but now it can be hybrid, in person and hybrid. And if you look at the QMUL report, it also shows that post-pandemic, if there's such term called post-pandemic, parties would like to go back to normal hearing if possible, but if not, it will be a hybrid hearing, which we will not be too surprised these days. Finally, I'm just going to summarize a couple of things before I'll let Professor Chi take over. In terms of the opportunities, I think ASEAN-China trade is rising and it continues to rise. Arbitration continues to take center stage. If I may take this opportunity also to say something about BAIAC Commission, which is the Domestic Arbitration Commission, the parent commission. Last year, they logged in about 56,000 cases, which is 15% of the total caseloads in China. And also, by looking at the BIT, the Singapore-Indonesia BIT, I suppose that this gives room and encourages further development and innovation in how arbitration procedures may be designed and devised in time to come that may eventually also help to eradicate some of the problems or complaints about arbitration. And also, there are increasingly a lot more visibility of a regional arbitration center. Although where credit is due, major institutions such as the Singapore International Arbitration Center, SIAC is it's also gaining a strong reputation internationally. If you look at the QMUO report, also it's also one of the highly sought after, if not the most sought after arbitration center, commercial arbitration center in the world. So there is enough room for every player. The pie is big enough for various arbitration centers, including like in the context of Thailand, the Thai Arbitration Institute or the Thai Arbitration Center doing its role to try to promote arbitration in the Mekong Delta region. And finally, I think there's a lot of, there will be room for the development of technology and hybrid system technology post-pandemic or endemic in this region. With that, thank you so much for your attention. And I'm happy to take questions later on. And I do apologize to Professor Shi, and I'll pass the microphone on. Thank you.
Thank you, Professor Ngo, for your presentation on the overview of arbitration laws in ASEAN countries, update on BATs between Indonesia and Singapore, and also the rise of Singapore as the popular seat because of many stakeholders' involvement in the process. Next, in the interest of time, may I invite Professor Shi to give a presentation on Chinese arbitration law and its recent development. Professor Shi, can you hear me right now?
Yes. Can you hear
me?
Yeah. Okay.
Yeah, I can. Yeah.
Thank you. Good afternoon to everyone. Let me start by thanking Dr. Amnet and Steve, Faculty of Law of Thammasat University and BAIAC Asia International Arbitration Center for this kind invitation. And also I congratulate the BAIAC Asia Center and Thammasat Faculty of Law for the signing of the cooperation memorandum. And actually, I'm a member of the committee for the BAIAC Center, which is a great pleasure and honor for me. So I'm happy to discuss with you the arbitration in China. So for the sake of time, I would just try to frameline my presentation in the following 4 major parts, and I just try to keep it short and succinct. First of all, I would just try to provide you with a very brief legal framework of Chinese arbitration law, so you know how arbitration is governed in China. And then I would provide you a few observations of the distinct features of arbitration in China. Steve has just mentioned major salient aspects of arbitration in many jurisdictions in the ASEAN countries, especially in Singapore, which is, of course, one of the most important arbitration hubs in the world. And then I move to the amendment of Chinese arbitration law, which is very recent and is supposed to be a earth-breaking movement in the arbitration mechanism development in China. And finally, I would also mention a little bit of investment state arbitration. I think it's getting momentum nowadays. Take this year, for example. We have three cases against China, and two of these cases were initiated by Singaporean investors against China. So let me start by the legal framework. So in China, what we rely on is mostly two laws, and the most important law is Chinese Arbitration Law, which was adopted in 1994. So that's over 20 years ago, and a lot of its provisions are now outdated, and this is the reason why there is a plan of the National People's Congress why we need to amend and revise this law. And just a few months ago, the revision draft has been published in China. I myself also was invited by the Ministry of Justice to contribute a part in this revision process. I will discuss this a bit later when I discuss the amendment issue. And aside from CAL, we also have another important law that is the Civil Procedural Law. The Civil Procedural Law, as you can see, mostly deals with civil litigation and commercial litigation in China, including foreign-related litigation, but it also deals with foreign-related arbitration because it involves the enforcement of arbitration. That is a major part of this law. I know that an audience has raised a question if I have a PowerPoint. I'm sorry, I don't have a PowerPoint. I just try to keep it very well organized so that you can follow me. I speak slowly as well. And aside from the CAL and the CPL, Civil Procedural Law, we have another major source of international law for the arbitration in China. Basically, that would be the New York Convention. Steve has mentioned the importance of New York Convention. And ASEAN countries are New York Convention contracting states, and so is China. China has acceded to New York Convention with two reservations. One is commercial reservation, and the other is reciprocity reservation. So basically, international arbitration, let's say foreign arbitral rule awards, using the term of New York Convention, could be enforced and recognized in China according to the convention rules, particularly Article 5 of the convention with regard to set aside of a foreign arbitral award. China is also a member contracting state of the ICSID Convention. This might be a little bit unfamiliar to many. This convention is under the World Bank that deals with investor-state arbitration specifically. So there are a lot of countries are contracting states to this convention. So China is a member of the ICSID Convention, which basically means that China is already signed on board of investor-state arbitration and bears a treaty obligation for investor-state arbitration, mostly based on the bilateral investment treaties. And aside from these international laws and national laws, in China, there was another source of law that would be a very important part of the legal framework governing arbitration almost every field of law, and that is the Supreme People's Court judicial interpretations. There are different forms of judicial interpretations. For the sake of time, I will not go through the details, but it's important that we note that the judicial interpretations of the Supreme Court, though in a strict sense, it's not law. They have binding force on local lower level courts in dealing with cases. And therefore, that would be setting kind of precedence, although I would say China is not a common law tradition country. So with these three different sources of law, we have the basic idea of the legal framework of arbitration in China. So domestic laws, very important ones, the arbitration law and necessary investment, international treaties, New York Convention and ICSID Convention, and a lot of special SPC, Supreme People's Court judicial interpretations. So with that, let's go to the distinct features of Chinese arbitration. Arbitration as Steve has mentioned, and I suppose that everybody knows, would be basically similar in one jurisdiction and the other jurisdiction. And this is actually the basic condition why arbitration could get popular around the world. In China, the arbitration is defined in the CAL, Arbitration Law. But in China, the arbitration has some distinct features. Of course, for the sake of time, I just focus on a few points that might define Chinese arbitration, or let's say that observers or people who are not really familiar with arbitration in China may find a little bit surprising. And the first of all is the institutional. Chinese arbitration law, Article 16, provides that one of the important factors that decides the validity of an arbitration clause is that the arbitration clause shall identify an arbitration commission. While the word commission could be broadly interpreted as to cover institutions that are not named as commission, for example, Singapore International Arbitration Center, it is a center, it's not commission. And in China, we also have arbitration institutions that are not named as center, commission. But the definition of a arbitration institution impliedly exclude the possibility of ad hoc arbitration. Most of the ad hoc arbitration cases actually under the UNCITRA arbitration rules. In China, this is impliedly prohibited. Although in very recent years, China has established quite a few special economic zones, and in some of the economic zones, like in Shanghai, Beijing, and now the free trade port in Hainan, there are certain advancement in this regard. Basically, ad hoc arbitration would still be deemed as a very exceptional situation. So the institutional requirement for an arbitration agreement basically means that at least a certain part of arbitration, that's ad hoc arbitration, are not allowed in China. So that's the general sense. If you consider that in today's world, of course, institutional arbitration seems to be prominent, but we do have a number of arbitration cases that are ad hoc, including commercial arbitration and investor-state arbitration. Around 1/3, about 30% of investor-state arbitration cases are actually ad hoc arbitration. So in commercial arbitration, because of the transparency issues, the data is not always transparent, but I suppose that there are a certain number of ad hoc arbitrations. Another distinguished feature is about the dispute. What kind of dispute can be submitted to arbitration? Of course, this would rely on the law, lex arbitri. Basically, that's where the seat of arbitration is situated. In China, we don't have the term of seat of arbitration, but we do have this kind of restrictions in arbitration law. So the arbitration law provides basically that contractual relations or property relations could be submitted to arbitration. This is a very vague categorization. In practice, of course, there are a lot of other kinds of disputes that might be submitted to arbitration as well. If you consider that in many cases, an arbitration clause would be very broadly construed and broadly drafted. For example, typical arbitration clauses would say any dispute arising out of or in relation to this contract or in relation to the performance of this contract shall be submitted to arbitration. So for these kind of terms, usually the tribunals would tend to interpret that in a flexible way. So the dispute issue would be a very, very outstanding issue to China. And the reason is because China has a limited scope of these admissibility of disputes. For example, when we talk about investor-state arbitration, that would be a hurdle. Chinese arbitration law would be an implied hurdle that would prohibit certain kind of investment arbitration cases to be submitted to China. because we know in almost all of these investment arbitration cases, the investor are suing the state. Most of these reasons are based on state administrative conducts. So in these kind of cases in Chinese law, most of this, if not all, would be categorized as administrative conducts, and therefore they should be dealt with in a way of administrative litigation or administrative review instead of arbitration. That would, of course, a great hurdle for China to develop investor-state arbitration or investment arbitration. And then another distinct feature is the pre-reporting system for the enforcement of foreign arbitral awards. China, as I've mentioned, is a member of the New York Convention, and China bears a treaty obligation to enforce New York Convention arbitral awards, that's foreign arbitral award. And therefore, when let's say a party submits an application to a qualified Chinese court for enforcement of foreign arbitral award, and then if the award, the court would have to be in the position to make a decision whether to enforce it. Now, normally the court has discretion to decide as far as the certain rules and law and New York Convention are followed. However, in China, because especially in the past years, there was this kind of local protectionism, local governments, local courts are sometimes reluctant to enforce arbitral awards, foreign arbitral awards against the local enterprises or individuals. And therefore, the Supreme Court issued a rule, and that's the pre-reporting system. Basically, that means if a court, lower court, plans to reject or set aside, let me say, to set aside the arbitral award, the local court will have to report it to the higher level of court. And the only decision, the decision of setting aside an award, New York Convention Accord, would only be made effectively by the Supreme Court. So this is a kind of centralization of adjudicatory power. I wouldn't say this is good or this is bad. The good side is, of course, it ensures the consistency of judicial practice. So the players would have a better anticipation of what will be the case, the result. But the not good side is that delays. There were a lot of delays, and then that would be the kind of efficiency loss to international arbitration. So that would be the pre-reporting system. And finally, there is another distinct feature, and that is about the nationality of arbitral award, which I understand to many is not only a theoretical issue, but also a practical issue, because you have to prove that this award is a foreign arbitral award under the New York Convention, or to qualify a New York Convention enforcement. But in China, we don't have that term as foreign arbitral award. We don't have the term of domestic award of foreign or international award. We have the term of foreign related award. The term foreign related is very broadly construed. Normally, if a party of a contract or of a legal relationship is a foreign party, or if the contract is signed, implemented, performed in a foreign state, then that kind of legal relationship could be deemed as a foreign related legal relationship. Here, the term foreign should also be broadly construed so that Hong Kong, Macau as special administrative region, and Taiwan as a part of China will be deemed as foreign for the purpose of arbitration award enforcement. So here we have these kind of distinct features. I'm not sure China is unique in the world, but as far as I can see that to China, there were a lot of discussions and criticisms of these kind of features. And these criticisms would also bring me to my next point about the amendment of the Chinese arbitration law. After more than 20 years of implementation of Chinese arbitration law, people gradually find the loopholes, the deficiencies, inadequacies of the Chinese arbitration law. And this is particularly the case if you consider that in recent decade, Chinese enterprises are investing abroad and a lot of companies are investing in China. There is a sharp increase of cases, arbitration cases. Steve has mentioned like Thailand Arbitration Center, Singapore Arbitration Center, and in China, if you have a look at the statistics from the major arbitration institutions, including the CTAC, China International Economic and Trade Arbitration Commission, or Beijing International Arbitration Commission, or Shanghai or Shenzhen Court of International Arbitration Commission, then you find that all of these major institutions have witnessed a sharp increase of caseload in recent decades. But with the increase of cases, these institutions as well as arbitrators as well, they find it really not satisfactory, the whole environment. So here in China, there, and also broadly speaking, there were a lot of discussions whether we could bring China into a international arbitration center, or let's say a hub similar to Singapore. So that would be a kind of discussion. But one of the reasons and one of the ways to achieve this goal is to amend the Chinese arbitration law so that China could be a friendly environment to international arbitration. For example, given the current situation, I wouldn't say China is not friendly, but of course, I mean, arbitrators may face a lot more difficulty if they have arbitration. In China, for example, you need to go to an embassy 2 months ahead of time of the hearing, scheduled hearing, to get the visa. And when you come to China, and then you, let's say you get out of the airport and you find a taxi and you see the taxi drivers can barely speak English, or not to mention other kind of foreign languages. I wouldn't say this is wrong. This is nothing wrong, but of course these would be an extra efforts for international arbitrators to go to China. These decreases their let's say the mobility and make them reluctant to get to China for cases. But those were only one of those inconveniences. But in law, we do have certain impediments that we need to overcome. The first of all, as I've mentioned, the institutionality, and the amendment draft has already deleted this. And therefore, that would basically mean that ad hoc arbitration will be allowed in China if this law will be adopted, the amendment of the law will be adopted, which is likely next year, if not sooner. So ad hoc arbitration would be allowed in China. That would basically open the door for at least probably 30% new type of cases to China. That would be a good idea. And at the same time, the amendments of law also highlight the requirement. In other words, they delete the original the arbitration law that arbitration can only take place between equal parties. Equal parties is actually not, strictly speaking, is not a legal term. In Chinese context, it's used mostly as a political narrative, or in the constitutional law. So basically mean that everybody, the institutions, we are equal before law. But this doesn't mean the parties exactly enjoy the same right and bears the same obligation under the same law. So this is quite vague. This term or this requirement actually bans a certain type of arbitration that involves non-individuals or companies. For example, investment arbitration and sport arbitration, which is getting popular nowadays, because the other party in, let's say, in investment state arbitration is state. In Chinese law, you can hardly deem a foreign state as an equal party with an investor, private investor company. Although if you check Chinese law, there is no law that is very explicit in this regard. That is basically implied. And in sport arbitration, for example, and that is mostly an international sport organization. That's the organization, international organization. And you can hardly say a international organization is let's say, a equal party with a private athlete. So that's something Chinese law has made, I would say, amendment, and has made great, I would say, progress, hopefully, if they were adopted. But as far as they are already in the draft amendment, I believe there is no compelling reason to delete them in the final draft. And of course, in procedural aspects, the draft amendment has also made some achievements, let's say progress. For example, the extension of arbitration clauses, the validity of the arbitration clauses extended from the main contract to a subsidiary contract, which is basically to help arbitrators or market players to get a better sense of predictability of the arbitration clause or arbitration agreement. There are a lot of these kind of progress and changes. I'm not able to discuss all these changes, given I think I have only a few minutes left. But I would be happy to discuss this issue in the future if any one of you, I mean, including audiences, have any interest in these regards. China, I would say, is not a UNCITRA model law jurisdiction, but that doesn't mean Chinese arbitration law has nothing to do with UNCITRA model law. China, in the drafting of even the existing 1994 arbitration law, has significantly referred to UNCITRA model law. But of course, UNCITRA model law is making revisions, and I believe that the next amendment of Chinese arbitration law would also draw necessary reference to UNCITRA model law, especially if you consider that the future Chinese arbitration law would allow ad hoc arbitration, and model law would be a very, very good template. So finally, I would like to spend a few minutes on investor-state arbitration. Investor-state arbitration is gaining momentum nowadays across the world, although there are a lot of criticisms on investment arbitration, including the long duration, the high cost, and the unpredictability or inconsistency of arbitral awards, to name a few of these criticisms. In many parts of the world, we see that the majority of these cases, investor-state arbitration cases, have been submitted to ICSID at the World Bank Center. And there are, of course, some other institutions that also taking such cases, like International Chamber of Commerce Court of Arbitration, Stockholm Court of Arbitration. The recent development shows that Asian countries are now pioneering in this regard. Singapore International Arbitration Center is the very first center, non-ICSID, that have stipulated a specialized set of rules exclusively catering for investment arbitration. And then after Singapore, CTAC in China and Beijing International Arbitration Center also promulgated their specialized investment arbitration cases. As far as I know, Singapore has already have a few such cases. CTAC and Beijing Arbitration Commission are still waiting for cases. But I believe that in the future, it is possible for these institutions to have such cases. China has, I would say, China is a host to more than 140 bilateral investment treaties and other kind of investment treaties, such as investment chapters of free trade agreements, including free trade agreement with ASEAN and a comprehensive investment agreement with ASEAN. Not to mention almost all ASEAN member states. So most of these bilateral investment treaties allow investor-state arbitration. So that means China is actually providing the way, it's already paved the way to foreign investors and also Chinese investors to rely on Chinese investment treaties to initiate investor-state arbitration. Today, we have around 6 or 7 arbitration cases against China initiated by foreign investors. We also have around a dozen cases initiated by Chinese investors against the foreign state. There are some notable cases. For example, the Shayapsheng case versus Peru. That's the very first case relying on China-Peru BIT in 2007, 2008 in ICSID. And very recently, and also in connection to Singapore, we have 2 cases against China raised by Singaporean investors. Even the high-profile case, Sanam, a Macau company, Sanam versus the Laos, they were actually fought in the Singapore court because the seat of this arbitration is in Singapore. So that would be a very, very high-profile case. So this would be the basic things. I believe that given the Chinese investors are now still investing abroad despite the difficulty economic situation in China and around the world, and also China is still attracting foreign investments. I believe that in the future we will see more investor-state arbitration cases relying on Chinese bilateral investment treaties. So that would be I would say a good field for lawyers, arbitrators, if you're interested in arbitration in China or with the involvement of Chinese arbitration law and certain things. So with that, I think I should stop. We still have like 10 minutes for questions and answers. Let me stop here by thanking again my host, the Thammasat University and BAIAC Center. Thank you.
Thank you very much, Professor Shi, for your very concise summary of Chinese arbitration law and also current updates in ISDS cases. So if I may, I would like to ask you a few questions first, and then maybe Professor Ngo may ask some questions if he have. So as you say, China is going through an attempt to modify the current arbitration law, right? And the previous version was what was enacted in 1994, and even though Arbitral model law was not used as the model, you also looked at it. So I want to know first about the interim measures, the issue of interim measures, because if you say that in 1994 you look at the Arbitral model law, back then it does not have interim measures provisions in Arbitral model law, right? So I want to know this year when you try to modify your law, would you discuss this matter in the amended version? And the second question would be, what about the role of the Chinese court? What would be the perspective of the Chinese court in general? Is it like pro-arbitration or kind of like against arbitration to an extent? If you can answer some of the questions. Thank you so much.
Okay, thank you very much. Let me first of all answer the interim measures. The interim measures in Chinese law, as far as you can see, the practice nowadays is that arbitral tribunals have no power to issue interim measures. This is different from other, not all, but many other arbitral tribunals under other rules. So the practical way is that if there is a need for interim measure upon the application of a party, then the arbitral tribunal would submit this to the arbitration institution. And because the law provides only the institution can apply to the court, the competent court, for an interim measure. So that is the basic way. So a party makes an application, then the tribunal would assess this. If the tribunal seems this is necessary, then it goes to the committee, the arbitration institution, then it goes to the court. So this would be something very, I would say, as you can see, very troublesome, and it could be delayed if you consider that interim measures could be very urgent cases. I mean, in a few days, you see that the bank account would be, could be gone. I would say, but that would be the problem. The revision of Chinese arbitration law, as far as I can see, yes, we do have these arbitration section. There is a section on the regard of interim measures, and basically the court can request for interim measures directly to the court or to the arbitration institution. I think this is in Article 43 of this amendment law. I'm not sure whether this will be exactly the provision if the law is adopted. And of course, if that is the case, we see that the implementing rules would be needed. How to do this? And this would be, I would say, would be something that also prompt mentality shift. As we all know, in arbitration, even if an arbitral tribunal has the authority to issue interim measures, in law, the arbitral tribunal usually would not have power to punish the party that is not really following that measures, except, let's say, certain kind of arbitration costs and these kind of considerations. But we will see in the future. But at least I believe that the law has already considered this question. And we will see how the implementation rules would be made in this regard. But a recent development is that we have this kind of memorandum between mainland China and Hong Kong with regard to the recognition and enforcement of interim measures. In Hong Kong, which is widely deemed as the UNCITRAL model law jurisdiction and common law, of course, jurisdiction, it is possible for the tribunals to issue directly interim measures, and that would be able, at least in theory, nowadays to be enforced in mainland China. Chinese arbitration institutions, as far as I know, have already taken note of this issue, and some of them have already made necessary rules to prepare. For example, in both Beijing and CTAC, Beijing Arbitration Commission, you see this emergency arbitration arbitrator system or the mechanism. I myself also served as emergency arbitrator in a major case, which I think it's possible in China nowadays. But of course, these cases are international cases, so the measures were actually the decision of the tribunal would be implemented or enforced outside China. So let's see what will be done in the future. Hopefully next year we will see the answers how this will be done. So the next question, do you mind repeating the next question a bit?
The next question is about the Chinese court. Like how do Chinese courts interpret arbitration law in China? If you can evaluate that.
Yeah, I mean, this is a very tough question, and it would be difficult to give a let's say a clear-cut answer to that. But in general, over the years, I believe there is a consensus around the world, and also not only in China, that Chinese courts are getting increasingly friendly towards arbitration, so that the interpretation of arbitration law and the actual discretion exercising by the court, in many cases, are actually favor arbitration. So basically, I believe that this would be a very good sign for China. A notable development is with regard to the reciprocity issue. In China, because of the reciprocity issue, China formally, this is not necessarily limited to arbitration, but it could apply to arbitration, is that formally the reciprocity would be only prompted if the applicant could show to the court that the foreign court in a similar situation has done a certain conduct that would be deemed as a favor or kind of favorable measure. And in that case, Chinese court would return in reciprocity. That's the way. But now the Chinese Supreme Court has, I believe it's the year before last, has issued a interpretation and saying that the Chinese court can take the first move without showing that there is already a favorable treatment from other jurisdiction. So I believe that this is moving towards, I think, towards more friendliness to international arbitration. But of course, in the same time, I realize, as do many arbitration practitioners and lawyers, that compared with some leading arbitration countries like Singapore, London city, Paris, and also compared with Hong Kong, mainland China is probably not really competitive. But this is caused by a lot of reasons, not only legal reasons, but also, let's say, convenience, as I've mentioned, and other reasons. Hopefully, I think with the adoption of the new arbitration law, hopefully next year, the situation would be further improved. And I hope that would be an opportunity for China to make itself a better destination or a better place for international arbitration.
Yeah. Thank you very much, Professor. Professor, will you have any questions or comments for Professor Shi?
Yeah, just a short remark and observation. And I think whilst the idea is not so much it's not so much about us being enamored about adoption of the model law. And I think most importantly is the substance more than anything else, right? It's the substance more than the form.
Yeah.
And with the revision to the Chinese arbitration law, I think that is a major step towards harmonization, or rather bringing the Chinese arbitration law in line with international practices. I think one of the major observations I've seen from the consultation paper or whatever it's called at this juncture before it's been the revision is put through, is that it addressed the point about the pathological arbitration clause. Yeah, I think that's one of the major points, because in the past, even if there's an intention to arbitrate, if there is certain defects in the arbitration clause under the Chinese law, then the arbitration clause may effectively be voided. But I think with the revised law, it actually allows that intention to be to respect the intention for the arbitration to take place. I think that is a very important feature as well. Yeah, I mean, of course, not every country in the world adopts the model law. The English Arbitration Act is an example. It does not adopt the model law, but it is an arbitration law that's quite in line with the model law. Yes.
Yeah. Thank you. If I may ask a question to Steve.
Yes.
I understand, Steve, is that not a question, but more than a comment. I appreciate a lot. I do have a question for Steve, as you're based in Singapore. As far this is a question that is haunting. I mean, on my part for a long time. Singapore is obviously very successful as a place for arbitration. In all senses, a legal jurisdiction or just a physical place for arbitration. So in recent years, as I've already mentioned, and you know that China has already planned to build itself as a kind of, let's say, Beijing and Shanghai probably be a center for kind of international arbitration. So what kind of lessons and experiences that you think that China might learn from Singapore? I think this is a very important thing. It's not necessarily a legal issue, but I think it's important. Yeah, I would be grateful if you can just share your insights.
Right, thank you. That is a difficult question to answer. And I have to be. I have to choose my words very carefully, because I don't speak for any government agency in Singapore either. But I think if you were to ask me this question, Cliff, I think I think on top of the list will be because of the common law tradition that is in Singapore. And although not the majority of the world is not common law jurisdictions, but I think the flexibility and the portability of common law seems to work quite well in arbitration. But again, this is not to say that civil law jurisdictions are not important or will lose out in terms of the promotion of international arbitration. That's number one. And number two, because of that, it's sort of it also helps in terms of how our judiciary has been in the forefront of international arbitration. Yeah, I think if I were to be looking at the list of judges in the Singapore Supreme Court, and also now with the establishment of the Singapore International Commercial Court, note that there is this mandate to go out and get arbitration experts onto the bench, but maybe because arbitration is important and has been very popular and very attractive, that in turn, for example, like the Chief Justice of Singapore, Sundaresh Menon, Chief Justice Menon, he himself was quite a prolific arbitration practitioner before he became a judge, and he even now he has delivered so many very thought-provoking speeches whenever he's invited to talk about arbitration. So I think that will be point number two on the arbitration, the judges and the judiciary. I think the list will go on. Maybe I'll stop at 3. I think the third thing is that I personally believe, I don't mean it. I don't mean it in any way that offends other people's belief, but English is a language for international arbitration. That would be my take. And so where we're coming from, Singapore, is that English is a key language spoken in Singapore, language used in a professional setting and the government as well. So like I said, the list will probably go on. A few others, not to say a lot, but if I'll just list out 3, this will be the 3 key reasons why.
Mm-hmm. Thank you.
Okay, thank you very much, professors. So time flies. It's been like 1.5 hours already, and I've learned a lot from both of you. Thank you for your insights. So unless you have any last words to share, do you two have any last words to share before we leave? Okay.
No, just
okay.
a thank you to both of you, and thank you to the audience.
Okay. Thank you very much, Professor Shi and Professor Ngo. We are on behalf of Thammasat, we are very pleased to have you with us today, and hope we can talk to each other or even see each other in person in the future. So if there are no further questions, thank you very much both, and I see you later. Thank you, thank you to the participants as well. Thank you, everyone.
Thank you, sir. Yes, thank you very much.
Thank you.
Thank you, and
bye.
bye.
Bye bye. Bye bye.